if I did not do something, then I should not have to be held accountable for something that I did not do. So it works both ways. I would say the same thing to myself if I did do something. I would be the first one to say, I'm going to have to take accountability for that. So why am I not allowed to be the guy that says, it wasn't me, right? I didn't do it, and I'm going to stand on that. And that's what I'm doing. I'm standing on it because it really wasn't.
I didn't, since you ask.
You gonna fit right in. Everybody in here is innocent. Did you know that? Hey, what you in here for?
Didn't do it. Lawyer fucked me.
Welcome to the Dummy Kruger channel, everyone. Today's video takes us to Hardin County, Kentucky, as we delve into the arrest of First Amendment auditor known as For Public Safety, an incident that transpired over a year ago at the Kentucky State Police Post 4 location.
There you are. Did he want to, he's got our complaints there. Oh, there you are. I'm Chris.
John.
Nice to meet you, John.
Well, you mind turning around, put your hands behind your back? You have an active warrant.
For what?
From 1999, possession of marijuana.
You're full of shit.
No, I'm not.
Yeah, you
Turn
are.
around.
I have never had marijuana.
Turn around, put your hands behind your back.
All right.
I didn't cover this arrest initially for various reasons. Firstly, the arrest had nothing to do with his auditing or quote activism. Secondly, the arrest was related to an outstanding warrant stemming from a probation violation that occurred over 25 years ago. For Public Safety's alleged probation violation originated from a guilty plea for possession of marijuana and drug paraphernalia. Certainly not the crime of the century. However, what transpired after the arrest is what really piqued my interest.
And the truth is, that never happened. I was never cited. I have never had any drugs or alcohol related incidents involving police of any sort. So this whole entire case from 1998, not 99 like John Goldsboro, the arresting officer, said, was concocted out of thin blue air. And for an entire year now, I have been defending myself and proving my innocence over a case that never truly existed for me.
For me at least, the intriguing aspect of this story lies in the conspiracy theory that emerged. Following the arrest, For Public Safety, also known as Chris, embarked on a years-long crusade to prove his innocence, suggesting either an imposter using his identification during the drug charge citation, or an elaborate conspiracy involving the Kentucky State Police, the Hardin County, Kentucky prosecutors, and multiple counties coordinating their attack on Chris throughout the entire state. While both scenarios seem unlikely to me, I maintained an open mind to the possibility that something was awry. I listened intently as Chris and his girlfriend Tiffany proclaimed on multiple occasions over the past year that they possess solid evidence supporting his innocence. In today's video, we will examine all the evidence they presented to their audience and the courts, starting from the weakest and concluding with what I believed could genuinely establish the existence of a conspiracy. Initially, I planned to wait until a conclusive finding had been reached before producing this video. However, the last piece of evidence I awaited has finally surfaced on YouTube, revealing not only that Chris repeatedly lied to his audience, but also that he lied on the stand during his probation revocation hearing. This entire saga is exceptionally wild, but I believe I've finally been able to make sense of the whole thing. Before we continue, please be aware that I may repeat myself several times throughout the video due to its convoluted nature, so please bear with me. Also, it took me combing through 15 plus hours of their content to properly tell this story, so be forewarned, it is a little lengthy. Without further ado, let's jump right in.
After going through all the case file, I found so many issues. There could be an imposter, okay? There could be someone that was using one of my licenses from back then. I am not 160 pounds. I am 240 pounds. The identification details of the individual they were supposedly looking for the past 25 years for a joint was 160 pounds. That ain't me.
Chris is telling the truth here. He's certainly not 160 pounds in 2023. But remember, this happened 25 years ago. So what did he look like then, you may ask? Well, he happened to look like this, which seems to be around 160 pounds. This is just a small example, but I'm trying to establish a pattern of him throwing anything and everything against the wall that he thinks will strengthen his argument with his audience. In the next clip, we watch as Chris tells his audience that the alleged defendant in this case never came to court at all, thus, conspiracy.
Well, how was the court going to keep up with this alleged individual? Well, they didn't. Nobody was ever summoned. Nobody ever received a warrant. Nobody ever learned that they had a court date. Now they're saying to us, the people that we're dealing with, are saying that I, back in 98, came to court and pled guilty. However, the records that are available indicate that the person didn't show up for court. Never showed up.
So, per Chris, this is all a complete fabrication because the person that allegedly pleaded guilty to this crime never actually came to court, much less started participating in drug classes that were part of the plea deal. However, months later on November 29th, 2023, during his probation revocation hearing, we find out otherwise.
On September 14th, 1998, the defendant was arraigned, and the case was continued for a pretrial conference on September 23rd, 1998. On September 23rd, 1998, the defendant appeared with a private attorney, B.J. Holycross, and entered a plea of guilty to the possession of marijuana. The defendant signed the terms and conditions of probation in the court file. On October 8, 1998, court has heard, the defendant met with CAPS and signed paperwork at CAPS on that separate date. On November 12, 1998, the defendant's court costs were paid in full.
So neither Chris nor his attorney contested these dates with the prosecutor. Therefore, when Chris claimed, quote, no one was ever summoned to court, or when he asserted, quote, the person never showed up for court at all, it is evident that he was not being truthful. Additionally, this has significant implications for his argument regarding an imposter or a case of stolen identity. The foundation of his claim suggesting that someone else showed up to court other than him collapses when confronted with the fact that not only did someone appear and plead guilty, but they also paid the associated court costs. This obviously raises questions about the plausibility of someone stealing Chris's identity and then willingly engaging in legal proceedings, including paying court fees. The prosecutor made the same argument.
And Judge, he apparently claims that an imposter was the one charged in that case, and that just does not make sense. And why not? Why does that not make sense? Your Honor knows you've been doing this a long time. It's not rare for somebody to lie about their identity to the police. That happens. Very often, the ones that get away with it are family members, often siblings, who know enough identifying information to seem credible. But in all those cases that I've ever seen, and I would guess that the court has seen, what happens after that arrest or citation? Imposters do not come back to court, Your Honor, at all, let alone multiple times, as was done in this case. Imposters do not hire private attorneys to appear with them in court. Imposters do not come to an appointment with CAPS on a separate date to sign the CAPS paperwork, as was done in this case. Imposters do not pay court costs at a later date, as was done in this case.
The fact that someone showed up to court, pleaded guilty, started participating in probation, and paid court fees, I think officially decimates any claims that someone actually stole his identity. Let's continue. So Chris tried another argument to support his claim of an imposter or a conspiracy against him. He correctly pointed out the absence of a mugshot or fingerprints in the file is yet another reason. Let's check that out.
So in the case file, I learned that there would be a mugshot from the a booking photo from the original arrest. The booking photo. That's huge. This is huge. So there's no booking photo from the 98 and 99 stuff. Everything else is there. It's almost like somebody removed it before I went and got the case file, because it would have to be there. It would have to be there. It's not there. Booking photos. Well, then again, yes, there was, but they don't have them anymore, and that's part of what puts them in a better position to use a case from 1998, right? So, and I think that they have the burden of the proof, right? They have the burden of proof because they're not going to show the fingerprint. They're not going to show the mugshot in that courtroom. So if you guys won't do that, then why shouldn't I be released? Obviously, there's a reason you're not going to show that to the judge. Why would it be? There's only one answer I can think of. If you have it and you won't show it to them, the only thing that means to me is there's a reason you won't show it. What is that reason? Guys, put in chat what that reason is. I'm not even going to say it. I'm going to let you say it.
Chris has been adamant this entire time that they were hiding the mugshot because it would show that it wasn't him. That would obviously be some solid evidence if a mugshot ever existed. Let's listen into what the officer that cited Chris in 98 said on the stand during the probation revocation hearing.
All right. Can I approach the witness?
You may.
Can you identify that document?
Yes, sir. It is a uniform citation that I had issued.
So even though Chris knew this, and what he didn't tell his audience is that no one was arrested or booked for this crime. The officer, seen here testifying on the stand, that it was a universal citation and a summons to court on a completely different date. Of course no mugshot was ever in the file because no one was ever arrested that night, only summoned to court later. This next particular excuse was, at the time, the primary reason I remained open-minded and opted to listen to his explanation before forming any conclusive judgments. Chris repeatedly asserted that it couldn't possibly be him because he possessed physical evidence proving he was in jail in a different county when someone was purportedly completing his probation a full hour away from where he was incarcerated. Physical proof. Huge, right?
And so the thing that bothers me so much is that I was in jail 45 miles away at the time that this alleged person was signing documents and taking drug tests. So peeing in a cup, showing ID to the probation officer, signing a paper on a date and saying, I'm here, I'm doing this CAP program. CAP is a drug treatment program, prove you're not on drugs. And but this person is on record in this file saying, I am here on this date. 2 of those meetings, I was in jail 45 miles away, and I have proof of it right here. I have proof that I never left that jail during the time that this person went to 2 CAPS meetings. So how is that not enough is my question. I don't understand. I mean, it's proof, right? Isn't that proof, guys? 1 for yes, 2 for no. They screwed up and didn't realize, the case that we picked couldn't have been him. He was in jail somewhere else, far away. I think they were.
Hey, you have someone asking, what county were you in jail?
Meade County, Brandenburg, Kentucky, and that's 45, maybe 50 miles away. And they never transported me out of the jail for any reason. So what I'm going to do on Monday is I'm going to bring the records that prove that it couldn't have been me. I was actually in a jail in a place called Meade County, Kentucky, 45 miles away at the time this alleged person, who was supposed to have been me, according to them, was signing documents and pissing in a cup. Couldn't have been me.
And boom, finally, here we go. Here we have some proof that there was either an imposter or it was this grand conspiracy. Did Chris finally run into some tyrants? Per what he was telling his audience, his own records that he's going to be showing the courts in a couple of days prove that it couldn't have been him. This thing is over, right? Let's see what he said directly after that court appearance.
There's nothing I can do. And there was nothing that this attorney could do in his eyes on that level, because it just felt like it was just too much to argue to prove that we didn't do it, given that we don't have the right records to prove that. So he's depending on me being able to prove where I was on 3 days for 25 years ago. Like, how would you?
I don't know how you could do it, Chris. You're the one that said you had the proof. You claimed only days prior that you could prove it. Here's what you said.
So what I'm going to do on Monday is I'm going to bring the records that prove that it couldn't have been me.
What happened to these records, Chris? Surely you weren't lying to your audience. Hell, I was even falling for it at this point.
And it can't be that I was at work, because they're saying, well, you could have missed a day. It can't be, here's my pay stubs that shows I worked 365 days that year. They don't want to use that. It can't be I was on vacation. Can't be that. Because you could have done it even being on vacation. It would have to be that you were out of the country. I mean, unless you can think of something that I'm not thinking of.
Ooh, I got this one. I can think of one thing. Prove you're in jail like you said you could.
So what I'm going to do on Monday is I'm going to bring the records that prove that it couldn't have been me. I was actually in a jail in a place called Meade County, Kentucky, 45 miles away, at the time this alleged person, who was supposed to have been me, according to them, was signing documents and pissing in a cup. Couldn't have been me.
Next, we'll examine something he strongly asserted as evidence of his innocence. The claim that some of the paperwork did not even bear his name.
So when the cop arrested me the other day, he did not have my name. It was a different name. The spelling of the name was wrong, which means he wouldn't have been able to use that as a point.
Because, that's right, they didn't even have my name. They had another name spelling, which was 3 out of 6 letters different than mine.
Again, when I mentioned I was keeping an open mind, it was precisely because of situations like this. If I were crafting a narrative for my innocence, asserting that 50% of my name was misspelled could be a tactic to dissociate myself from the charged individual. Chris's lawyer really hammered this during the hearing.
And that's why it's got.
What was the name that was on there?
Ritter, R-E-I-T-T-R.
Is that your name?
No, sir.
Now, here's another document. This is already in the record, Your Honor, the citation. Here's another document that's a warrant. Do you recognize that document? It's a warrant of arrest.
No, sir. Other than after the case, I do have it existing and be getting records.
Whose name is listed on that warrant?
It's spelled incorrect, so it's spelled R-E-I-T-T-R, Christopher L.
Is that your name?
No, sir. 25 years is a long time.
This is the terms and conditions of probation. And is that name on there listed as defendant, is that spelled correctly?
It's spelled R-E-I-T-T-R.
Is that your name?
No, sir.
So, once again, as it turns out, it wasn't 3 out of 6 letters that were incorrect as he claimed. It was only one letter. The paperwork read Reiter, R-E-I-T-T-R, when his last name is actually spelled R-E-I-T-E-R. That doesn't seem near as bad to me as 50% of the name spelled erroneously. This gets cleared up even further when the prosecutor questioned the officer that cited Chris 25 years ago.
And I wanted to call your attention to the name there. There's some question about the spelling of that name and what do you see there as far as what's on your citation?
Right, based on what I now know, of course, with the correct spelling of the name, there appears to be some misspelling on that last name. And there is, when I was writing it, I believe I may have not seen that extra E, so I think I tried to just add the E in there. So it's poor penmanship on my behalf, I would assume.
So, was it great police work? No, not really. Could it be chalked up to human error? Certainly. Is it proof of a conspiracy or that it was in fact a different individual altogether? No, of course not. Chris's attorney questions the officer about this misspelling as well. Let's take a look at that.
And you have acknowledged that on the paperwork that was submitted, the spelling of the defendant's name is wrong and the address is wrong.
I did not say that, sir. I said that I may have had poor penmanship on the last name.
Well, was there something on there that caused confusion about that? How did you spell the name on the arrest slip?
On the citation, it was R-E-I-T, and I had another T and then an R, and I had mistakenly left the E out, so it looked like I just, at that time, maybe added a little dash to indicate the E for the spelling. So
okay,
not a commonly spelled name, I would say.
Initially, the name was wrong.
Initially it was, misspelled, and then it looks like I may have tried to correct it post noticing of the error.
When was it corrected?
It would have been at the time of the citation issuing. I wouldn't have any, once at the end of the day, I would have separated this was the old carbon-less citations. I would have separated all of that. I would have had no opportunity to change any of that post.
But you don't remember when it was done exactly. Would that be accurate? You don't have any memory of when you filled out that paperwork?
I do. I would have filled that out at around approximately 3:30 in the morning on August the 22nd of 1998.
Okay.
I would have filled it out when I did the citation.
Again, what's more plausible here? A grand conspiracy to lock up Chris for a maximum of 30 days? Or a penmanship error? Let's keep going. So this next one is quite similar to the misspelling of his name, but it is a little bit more intricate. Saying that, it's also very telling what he tells his audience versus reality. Let's now take a deep dive into the case of the non-existent address that exists.
The address never been attached to me in my life, so he didn't have that. And then the address on the original warrant never existed, guys. It's not an address. So I don't know what the hell kind of police work was going on, if it was ever real, but it didn't exist. The address didn't exist, so none of this makes any sense. There was never that address. That address never existed. So the citation for the original charge never did exist. Therefore, all of the court proceedings, as well as a dumbass cop needing to be losing a case just because he's too stupid to write the right things on a form.
The address that they said the incident occurred, the arrest, was never in existence in any time in history.
Sounds crazy, right? If the address doesn't exist, you must acquit. Let's look a little deeper into this.
Is that your name?
No, sir.
What address was on there?
137 Morgan Street, lot 2461, Radcliffe, Kentucky, 40160.
Was that your address?
I'd never heard of that address in my life, sir.
Here, he's absolutely correct. 137 Morgan Street, lot 2461 doesn't exist. If the address that the alleged violation doesn't exist, that has to be ballgame, right? Not so fast.
And also, I believe the original court file, what is the address you have listed on it?
The address that I had responded to was 137 Morgan Street, and it would have been lot 246.
Okay. Not 2461?
No.
Okay. Do you know where someone would have come up with that?
The address in the offender violator section looks like that may be a 1 at the end, but that likely could have just been some over marking from another piece of paperwork I was filling out, perhaps. But the exact location of the arrest and violation, as noted under the date and time section, does reflect lot 246. Okay. And the address is not incorrect. The address that I responded to is 137 Morgan Street, lot 246. The offender violator address looks like there might be a mark, an ink mark that may have been further to the right of the lot 246. That could have been an overmark for me. I probably had a lot of paperwork in my hands and writing a lot of things. So, but the exact location is noted as 246. So that would have been the correct address.
So you won't acknowledge or agree that there's an inconsistency regarding the address on that paperwork?
I wouldn't agree that I had made a mistake in writing the address. That extra mark is not a 1. I have written numeral 1s many times on this page, and that is not consistent with a 1.
Okay, that's all, Your Honor.
So the officer testifies that the 1 at the end of the numerals isn't a 1 at all, it's just an errant dash that made its way onto the paper. Also, per the officer, there was another section on the same paperwork that doesn't have the added mark that just reads lot 246. But don't take his word for it, because I have a lot more receipts about this address. Let's continue.
Who lives at 246 Lee Way?
I have no clue. Okay. I went to that address after I realized this case existed, and I was told by the manager and owner of the trailer park that the buildings, the trailers that are on it, don't go past 205. So there's no way either one of those two numbers. That's what I was told by the owner.
Okay, well,
Maybe he was told by the owner that the lot doesn't exist, or maybe he's not telling the truth. Either way, it's false because this is lot 246 right here. However, you'll notice the address in the top left-hand corner actually reads 246 Leah Way and not 137 Morgan Street, lot 246, which is the address the officer responded to. More on that in a minute because I know it sounds confusing.
But that 246 Leah Way address, was that your address?
No, I've never. I lived in Indiana.
Did you catch that? It's a completely different address than every bit of the record. And looking back on it, maybe she did live on Leah Way. I don't know how that's relevant other than the fact that it does have 246 in that address. It's not the same as everything that was on all these court documents, which was 137 Morgan Street, lot 2461.
All right, here goes. We know that the officer was called out to 137 Morgan Street, lot 246, not lot 2461, because first, it doesn't exist, and second, the officer testified it was an errant mark that didn't match any of his other ones on that piece of paper. So what's the deal with 246 Leah Way? Well, let me show you. When you Google 137 Morgan Street, lot 246, it takes you to the main office building of the trailer park they were living in. A trailer park which is massive. If we continue down Morgan Street and take 2 lefts, we remain in the trailer park, but at 246 Leah Way. So, yes, Chris, it's very relevant. Not only that, but when I searched for previous residents at this address, I found Georgette on 3 different websites. I have redacted her last name because she was involved in a domestic violence situation with Chris a few months after he was cited for this drug charge. We know this is Chris's ex-girlfriend's name because she filled out the complaint against him on August 4th, 1999 for that domestic violence situation. So, to wrap all this up, we know Chris was dating Georgette at the time of his citation because he says so during this hearing. We also know that the officer that took the stand was called out to 137 Morgan Street, lot 246, which today is known as 246 Leah Way. We also know through searching that address that Georgette did in fact live there during this time. But that's not all.
Do you have any explanation as why there's an insurance card with that address and your name on it?
That is my ex-girlfriend's name right there.
And that's also your name, right?
Well, I didn't have insurance with her. I wasn't married to her.
Okay, but that's your name and that's an address that you say you were never at, correct?
I'm sorry, can I see that again, please? Just because I've never seen this and I wouldn't understand why she would have insurance and have my name on her driver's insurance. That's what it looks like to me, is that she got insurance and put my name on her driver's insurance.
Okay.
And then there is, yeah.
You remember her living at that address at some point?
No, I do not.
Okay. Okay. Do you remember being required to show proof of insurance to the court
To the court?
as on an order of probation.
Can I see it?
That's it right
Okay.
there.
No, I do not remember this at all.
Okay, and you deny that's your signature, is that right?
It's not, doesn't look anything like my signature.
So now we have more information that Georgette, his girlfriend at the time, did in fact live at the address because her name, along with Chris's, were on a car insurance policy together, naming that address the officer went to in 1998 for a welfare check. And why did the court have this document? Because someone, Chris, was required to show proof of insurance during his probation. I'm still not done.
You heard this officer testify, this former Radcliffe police officer testify about a run he made to a residence. Do you know anything about that run?
I wouldn't know anything about that run other than what I've seen in these documents after doing.
Did you hear his testimony that involved a welfare check of a juvenile?
Yes, sir.
Do you have any children?
No, sir.
Did you have any children living with you in 1998?
Not at all, sir.
So Chris is telling the truth that he doesn't have any children. But notice what isn't asked during this line of questioning. Did his girlfriend, Georgette, have any children? We know that she did because in the paperwork for his 1999 assault/domestic violence case involving Georgette, she was asked if she had any minor children. Georgette did have a minor child in the home. According to these documents, she would have been 4 years old at the time. Alright, we're going to move to the last clip regarding this address, and it's a big one because his lawyer inadvertently proves it was actually Chris.
The next document is an affidavit for violation of probation. And I think you heard that former probation officer testify about that.
Mm-hmm.
That was mailed out. Was that mailed to your address?
No, sir.
What address is that listed on there?
35 Chester Lane, Brandenburg, Kentucky.
Did you ever live there?
I did live at that address a year after all of this.
Did you live there in 1998
No, sir.
or 1999?
At the middle of 1999, I lived there for 2 months.
Okay, did you receive that notice?
No, sir.
Okay, did you catch that one little detail? In 1998, when Chris received the citation for possession of marijuana, the court documents listed the address as Morgan Street, Lot 246, now recognized as 246 Lea Way. However, in 1999, when his probation was revoked, the official document was mailed to 35 Chester Lane, Brandenburg, Kentucky, an address Chris admitted to residing at. We also have evidence confirming that both Georgette and Chris lived at this new address together, as it is the same location where he was arrested for his 1999 assault case. Everyone following along so far? Alright, now, how does this substantiate that it was indeed Chris in question? Consider this, the probation office sent the revocation notice in August 1999 to the new Chester Lane address. The crucial point here is, how would the probation office send this notice to an updated address if Chris, the person under probation, hadn't informed them of the change? Was it the supposed imposter abiding by Chris's probation rules at the time, updating the courts that he had moved the same place Chris had moved? Or was this part of a larger conspiracy? I think we all know the real answer.
If you would, you may call your witness.
Yes, sir.
Mr. Ryder, step to the podium if you would, sir.
I think you got all this
Good afternoon to you.
Good
If you would, sir, come step to us. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Absolutely.
Take the stand, sir. Watch the step as you come around. As you testify under oath. Speak to the microphone very clearly.
The prosecutors have gotten so desperate in this case that I believe that they have even fabricated records in my real case documents from back in that time era just so that they could put a false signature, because that's all the prosecutor really had to use, was to suggest that they had matching signatures from the fake case that they're bringing to this court and in another case which actually existed, but the document in the other case that actually existed couldn't have existed. It was a bond form saying that I bonded out of a jail in 1999. But I did not bond out of the jail in 1999. I stayed in the jail until the final hearing, in which I saw the judge and then was released. So where did that record come from? I'm not real sure. Somebody probably slipped that in there.
Recall at the beginning of the video where I said I was going to wait until the judge made a finding in the case before I made this video, and that I changed my mind because a crucial piece of evidence surfaced? Well, we're about to take on his biggest lie yet. And let me just tell you, it's a bold one. For a little context, the prosecutor is about to question Chris on the stand about two matching signatures. The first signature is from the Hardin County drug possession case in 1998, the reason why we are here. The second signature that the prosecutor will be using is from the assault case he pleaded guilty to a few months later in the spring of 1999. The prosecutor aims to demonstrate that the individual who signed the documents in the 1998 case, which Chris denies as his own, is identical to the individual who signed a document related to his assault case in 1999. These signatures are almost exactly alike. How do we know they look almost exactly alike? Well, Chris told us, of course.
It's crazy, you guys. This is just, it's nuts. The lawyer a couple weeks ago gave Tiffany and I a few more documents from different cases. One of them is this Meade County case from 99, and showed me a page with a signature on it that looks a lot like the signature they're using in Hardin County. It does. It looks a lot like it.
Unfortunately, I don't have the 1998 signature to compare, but this is his signature from 99 that he claims is fake. But it's not. And I have the proof. Let's watch some clips of Chris being questioned on the stand by the prosecutor, as well as some clips of what he was telling his audience 45 days prior to this hearing.
You were charged with assault, fourth-degree domestic violence in Brandenburg or Meade County in 1999. Is that correct?
Yes, in 1999.
You were arrested for that. Is that correct?
That is correct.
Okay.
I don't recall the actual charges.
Sure. Judge Matt is the exhibit there.
When you reference, is that what you reference?
Yes, sir. Thank you. Let's see. You were released from jail on a $1,000 cash bond. Is that right?
That is incorrect. That is not correct.
Okay.
Right.
Because it's on a bond sheet. So the one thing that's in that record says that there was a bond paid of $1,000. Guys, I didn't pay a bond in that case. I didn't leave the jail until the whole case was concluded. I was OR'd after serving the full amount of time from the time I was arrested until the time the judge decided the case. There was no release for no bond, because I can assure you, and I have plenty to back this up, I did not bond out. So therefore, there could not be a paid receipt for a bond with a signature on the 1990 case in Meade County. It can't exist.
Is that the bond paperwork that you signed in 1999?
Yes, I have been questioning this paperwork.
It is easier to conceive that somebody potentially went 50 miles over to another county and put this paper in or something.
Okay. So
I didn't know. The answer is no, I did not sign it. That does not look like my signature.
Okay. Okay. So you acknowledge the case, the charge, but you deny signing paperwork to get out of jail.
Well, I didn't get out of jail. Not until after the final hearing. I didn't bond.
If you're not following, there's 2 counties involved now. 2. Here's the deal. So they're saying that that I signed a paper in that Hardin. I'm sorry, I just did it right after I told you not to do it. In the Meade County case, they're saying that one of the records in that case file has a signature on it. And they're alleging that that signature matches the signatures that they have in the Hardin County case, which I believe has been completely fabricated.
And I don't remember the charges, so I can't verify those either, I'm sorry.
Okay. Do you remember you were charged with some type of assault charge?
I don't remember the charges.
At all?
I don't remember what they were on the case. I do not remember the charges.
You know you were arrested,
Yes, that's true.
but you don't know what the charge was?
I don't remember the charges. I really don't.
Okay. Well, if the record suggests it was assault, do you dispute that?
No, I wouldn't dispute that it could have been.
Okay. You mentioned a girlfriend at the time. What was her name?
Georgette.
Okay. So, if the document says bail posted $1,000 500 feet away from Georgette, does that ring a bell? Does that sound like the case you're involved with?
You're asking me if that's what's on the document?
That's what's on the document. I'm asking you, does that ring a bell?
I'm sorry, I'm misunderstanding the question. Yes, that's what this says.
Okay. Do you recall that from that case?
From the case?
Yeah.
Yes. So when I left court, I agreed to have no contact with her.
Okay. But you do not believe you came back to court on a couple of weeks later or 9 days later?
Sir, I was already in the jail and came out from the jail to that court date.
But I did not bond. I didn't even have the money to bond, nor did I even try to get out of that jail. I did not try to get out of that jail. I served the little bit of time that was there. I wanted to show that in the courtroom at the time, back in '99, in the Meade County case, that on the final hearing, I'm in an orange jumpsuit and chains. So I didn't bond out.
Oh, okay. All right. Is that what the video shows?
We're waiting on the video to come back.
I'm sorry, Judge, I took this.
That is what the video will show.
Right there. That last line is why I wanted to wait. Quote, that is what the video will show, unquote. Referring to him being brought into the courthouse in an orange jumpsuit and chains, and that he never left after he was arrested, and that he didn't post any bond. Therefore, the document with his signature is clearly fake. So what do you guys think the video shows? Well, let's take a look.
Georgette, Christopher Ryder.
So that's Chris walking in right here, but something sure seems off already.
I wanted to show that in the courtroom at the time, back in '99, in the Meade County case, that on the final hearing, I'm in an orange jumpsuit and chains. So I didn't bond out.
Oof, already caught lying in the first 15 seconds of the video. Let's keep going.
And what are we doing on the criminal charge? He's going to go ahead and have a guilty plea, Your Honor. The Commonwealth's going to recommend. You need to raise your right hand, Mr. Ryder. Do you swear the statement you make to be the truth and nothing but the truth, so help you God? I do. Do you understand you've got a right to a jury trial, got a right to confront witnesses against you, such as the police officer and Mr. here when you plead guilty, give up those rights? I do. You understand you got a right not to testify against yourself when you plead guilty, give up that right. You admit you're under oath guilty of assault in the 4th degree. I do. Are you under the influence of alcohol or any kind of medicine or any other substance here today that keep you from understanding what you're doing? Have you ever been treated for mental illnesses? No, I haven't. Are you entering this guilty plea freely and voluntarily? Yes, I am. Are you satisfied Mr. Scott's services on your behalf on the assault charge? Did you discuss the plea with him? Oh, yes. And you satisfied his services as your lawyer on this assault charge? All right, court, accept your guilty plea and the recommendation. 6 months, Your Honor. They're going to give him credit for time served. The rest will be probated. And the conditions to be 5 by the terms of the domestic violence. How many days did you get? You got 1. Okay. Be sentenced to 6 months in jail, probated after the 1 day he served. The rest of the time probated for 2 years. No other public offense and no contact with Ms. Garcia.
And there's oof number 2. Recall, even though all of the paperwork from this case was showing that he was arrested on April 4th, released on April 5th, and returned 9 days later on the 14th to plead guilty, Chris has been saying this whole time he never left and that the paperwork was clearly fraudulent. This was the conspiracy.
I didn't leave the jail until the whole case was concluded. I was OR'd after serving the full amount of time from the time I was arrested until the time the judge decided the case. There was no release for no bond.
But now, after seeing the video, we see that he in fact did leave because according to the judge and Chris himself, he only spent 1 day in jail, which is not what he said on the stand years later.
But you do not believe you came back to court on a couple weeks later or 9 days later?
Sir, I was already in the jail and came out from the jail to that court date.
I was not in jail for 1 day. I was in jail for a lot of days. But on the Meade County Court document record, although it shows the full time for the case, for some reason somebody put on there, right on the front, that I only served 1 day in jail.
The court accepts your guilty plea and the recommendation.
6 months, Your Honor. They're going to give him credit for time served. The rest will be probated. And the conditions to be abide by the terms of the domestic violence.
How many days did you get?
We got 1.
Okay.
So Chris did post this $1,000 bail, therefore Chris did sign this document, and since this document matches the 98 document per Chris, it was Chris that was caught with the possession in 1998. It's over. Full stop. But I'm still not done.
Court calls. How much?
It's going to be $105.25.
$105.25. When can you pay that?
Can I pay it in sections?
$50 by May the 12th, and then the other $50 by the 2nd.
And she put up his own loan.
How much is it?
$1,000. Take it out.
Can I pay it in sections?
$50 by May the 12th, and then the other $50 by the 2nd.
And she put up his own loan.
How much is it?
$1,000. Take it out.
And let's see, you were released from jail on a $1,000 cash bond, is that right?
That is incorrect. That is not correct.
Okay.
Right.
Because it's on a bond sheet. So the one thing that's in that record says that there was a bond paid of $1,000. Guys, I didn't pay a bond in that case.
I have to get a place to live.
Pay out of that and you get the rest of it back. I can't give you $1,000 back. And
Well, I'm giving him $500 today, and it's going to be
I've got to take it out of there if it's your money.
all of it.
Yeah, it's $100.
So that was the end of the hearing, but we have even more proof that Chris did bond out, and that he did sign this document because the $100 in court costs that he accrued was taken out of this $1,000 bond. The irony is just too sweet here, guys. This couple has been going around Indiana and Kentucky demanding public records for over a year now, sometimes on the spot. These occurrences often resulted in major confrontations with court staff, DCS staff, you name it. So after all of that, all of the fights, all of the conspiracies, all of the call flood requests, it was public records that officially fucked him in the end.
Hey, phrasing!
My bad. So, after all of that, you would think that would be all I have. But I actually saved the biggest lie for last. Who's ready for it? Roll the clip.
So you acknowledge the case, the charge, but you deny signing paperwork to get out of jail.
Well, I didn't get out of jail. Not until after the final hearing. I didn't bond.
Oh, okay. All right. Is that what the video shows?
We're waiting on the video to come back.
I'm sorry, Judge, I took this.
That is what the video will show.
And at this point, that video did come back finally, and it does show that I had been in the jail the whole time. We'll go over that later on the channel.
That's right. In the middle of Chris's video showing this revocation hearing, he cut in to tell his audience that he did in fact get this video here, saying that it indeed showed him not leaving jail. This is what I was waiting on. I was waiting on Chris to actually prove his conspiracy, but alas, he never released it. We now know why. So the judge is still considering the facts of the case and has yet to make a ruling. He did say something to the effect of, is the juice worth the squeeze? Meaning, is it worth throwing him in jail for 30 days after all of this? Which, quite frankly, I get. It's such an old case with a rather minor original offense. If the judge finds him guilty or not really wasn't the point in me making this video, however. It was to show the lengths this couple went to deceive their audience. After spending a week producing this video and combing through hours of his lies, I found myself wondering the motivation behind such an act, ultimately leading to a few theories. Maybe it's as simple as not wanting to go to jail for 30 days. I could certainly understand that. It also could be that these two always play up the victim card in every single one of their videos. No matter the situation, whether it be not getting an appointment of their choosing or claiming to be illegally detained by an elevator.
Oh, they locked me in the damn elevator. Okay, this is an unlawful detainment.
They always portrayed themselves as victims of a tyrannical government. Furthermore, this arrest, along with the hours of content it generated for their monetized YouTube channel, significantly boosted their viewership. At the time of the arrest last year, they were averaging about 100 live viewers per stream. By the time of his hearing in November, they were regularly bringing in over 1,000 viewers, a huge tenfold increase. Saying all of that, could it just boil down to the obvious? Bunny, this arrest was the catalyst that kicked off not one, not two, not three, but 4 different GoFundMe campaigns with donations totaling almost $15,000, all predicated on a lie. If I really had to guess the motivation, that would be it. Occam's razor, right? The simplest answer is typically the correct one. Alright everyone, I think we can finally wrap this one up. A big thanks to everyone that checked out my video, and especially those who made it this far. This is Dummy Kruger, and I'll see you on the next one.
Raise your right hand. You swear to affirm to tell the truth, the whole truth, and nothing but the truth.
Absolutely.